And let me tell you, these prosecuting attorneys and these lower court judges, and especially in the traffic courts, don't even understand their own rules, or if they do, they certainly don't follow them. Now, there are some pretty sharp judges, and boy, once in a while, here in Ada County, we'll take one of those sharp judges, and he'll dot every I and cross every T and lay you away every time. But I'd say about 90% of the time, and about 90% of the prosecutors and judges, they're so used to shearing sheep that they don't have any comprehension, or if they do, they certainly don't let on that they do, to what due process of law is. They just break the rules and violate the law willy-nilly. If you don't think so, take a look at Miranda versus Arizona again and review that. Did you notice what your Supreme Court said about these people breaking the law? That the policemen break the law constantly, putting lighted cigarette butts out on witnesses' backs. Would you take these over here, partner, and make sure that these get into this tape? All right? I think I've covered this subject matter now of the subpoena pretty carefully. Now, and I talked about the parking ticket and due process of law. Remember that there are dozens of cases on due process of law, and if you want to have in your computer a good knowledge and a good understanding of this thing of due process of law, read these due process cases here in not words and phrase, but legal quotations. Take your book, Legal Quotations, and there's probably 40 cases. Now, if you'll just take 2 or 3 of those cases on due process and go to the law library and read them, I mean the whole case, take you half an hour or an hour, there'll be a large number of citations, because every time the Supreme Court makes a decision on any particular case, they'll always quote 10 cases in each one. That's called shepherdizing. That's added on to your original topic. And so you're looking at a case called Fisher versus Pace on contempt of court, and you want to see some more contempt of court cases. Then in the Fisher versus Pace case, there'll be 10 citations. We decided that, and we saw that, and in this case that, and you read those. And by the time you've read 10 or 15 cases, you're going to have a tremendous amount of knowledge on contempt of court. Same thing is true about each and every topic that you need to know about. And this thing of law, when you start, as I've told you before, you take a look at this big steak, and here's this giant T-bone steak, and you say, I could never eat that whole steak. Yeah, that's right, because your mouth isn't big enough. But if you could cut it up into 32 pieces, you can consume it in 32 bites. Now that you can do. And that's all I'm telling you to do. Now, if you'll take a look here and you're looking at your course outline and you're looking at 30 lessons, and each one of those lessons is divided up into, like this one here called Service of Process, 1, 2, 3, 4, 5, 6, 7 items. But if we cut those 7 items up into 7 bites, nothing to it, is it? So, now you know what due process of law is, and you're going to read a few cases, and you're going to have an understanding about what the court means by due process of law. Due process of law are the rules of criminal procedure, all 54 rules. And so, when the rule of procedure says that you're entitled to the transcripts of all of the hearings, you write a motion, and you file it with the court, demand oral argument, and walk in and say, Judge, it's necessary and imperative for me to have the transcript of the bail setting hearing, the arraignment, and the first motion hearing in order for me to prepare for trial. And I'd like you to order the clerk of the court to prepare those for me. All right, now, you either get the tapes or you get the transcripts. If they refuse or they just neglect, then they have violated one of the rules of due process, haven't they? You see how you set them up? You see, there isn't a person in 1,000 who will exercise Rule 5.2 and will demand those tapes or transcripts. You want to be that one person in 1,000 that says, I've got a right to it, and I want it, and I want it now. And I'm not prepared to go to trial without it. And I demand all of my rights at all times. Now the issue isn't did you or didn't you do it. It's why didn't you give the man the tape so that he could prepare for trial. All right? Now, we covered this thing of the parking ticket. A parking ticket is simply a summons, and I don't care whether you got a summons, a traffic ticket, or whatever it is. You make sure that you get a file folder started, and each and every one of those items that you put in there, you get that in there in chronological order, and you get a nomenclature going. This nomenclature is 3 pages. Look at this. And you've got a copy of this right in front of your eyeballs. And if you don't think I mean business when I go into the courtroom, my nomenclature tells you I do mean business. And there's another important reason for having this nomenclature, because you know when you're in a motion hearing and they're trying to confuse you and cause you to lose your train of thought. That motion hearing is yours, and you call up the order that you want to talk about these motions. And so what you're doing here is you're saying, Your Honor, I'd like to bring up number 9, jurisdiction brief, memorandum of law in support of jurisdiction. And that is status to contract. And if you'll look on your copy, Your Honor, it's number 9. And so I look in here, number 6, number 7, number 8. Here I am. Ladies and gentlemen, here it is, number 9. Do you see how fast I pulled that out of that file? And up here in this upper left-hand corner is the number 9, and it's circled. And here's what I did. I circled the numbers. Remember, there's 3 copies of all of your motions and briefs and paperwork that you're serving on your adversary. So you number the judge's copy and your copy. Don't number the prosecutor's copy. Now you call them up. Your Honor, I want to talk about number 9. That's the next motion, and I have some more data and information that I'd like the court to be aware of, and I want the court to take judicial notice of these facts. This is number 9, Your Honor. You pull out number 9. The judge, he pulls out number 9, and the prosecutor's sitting over there. Excuse me, Your Honor. Which one is that, sir? I don't know if I have that. See how a little psychological warfare works? And I just sit here and say, well, I guess we'll have to wait until the prosecutor finds his paper. Oh, the silence gets deafening. Let the little flat-chested twit sit over there and squirm and wonder about what's happening next. That's the way I treat them. You know they're going to do that to you. And remember, you're going to have to develop that killer instinct. And so here's the judge sitting up there. He's got the paper, and you sitting there with the paper. The judge knows exactly what you're doing, and you know what you're doing, and it doesn't take long for the prosecutor to figure out what you've just done to him. See how that goes? Like I say, I play the game to win, and I play the game to have fun. If you're not having fun at the motion hearings, if you're not having fun when you go to an audit with the IRS, you're not conducting it right. That's all that boils down to. Right, so here's your file folder. Here's your nomenclature. One of the rules that you've got to understand now is that 50% of your case is wrapped up in these motions, in writing. And 25% of the case is going to be wrapped up in the procedure. That is the rules. So you need to know the rules. 25% of the case is wrapped up in your oral argument or your ability to perform and your ability to speak. If you're not a good speaker and you say to yourself, well, I can't write and I can't speak and I dropped out of school when I was in the 8th grade and boy, I just don't know, how I'm ever going to perform in the courtroom. I'm going to send you a brief that's written by a man who dropped out of school in the 8th grade. He's from, I think he said he was from Missouri, and he was raised in the hills of Arkansas. And I'll tell you why I'm going to send you this brief. This guy has argued about 15 cases in court, and I don't think he's ever been defeated. He hasn't graduated from school. We just got in contact with him here not too long ago, and I think he wants to come to school here, and he's relatively new, but he's arguing a malicious trespass case. Something on that order. And I'm telling you, this guy, the reason I'm not going to read this to you over the TV screen, you've got to look at this thing, and you've got to read it with your own eyeballs. And I'm going to use the man's name. It's Del Bowman. So you pull out this brief from Del Bowman, and you read that brief. Because let me tell you, friends, it may not be articulate, and it may not be a piece of prose written by F. Lee Bailey or Melvin Belli, but let me tell you, there isn't a judge in the country that couldn't read that brief and know just exactly how that man laid his case out in spades. So if you think, well, I could never do this, you read that one, and I'll tell you, this guy can do it, and he can go into the courtroom, he wins every time. And if he's lost, he hasn't lost over 1 or 2. Certainly not over 1 or 2 that I know of. And he's argued some heavy cases, and some of them have been felonies. And they've been after him for a long time, because when you're demanding constitutional rights, and when you're out there arguing with your government and threatening to upset their power base and threatening to upset their money machine, you're going to invite some trouble. And this fellow's been doing it for a long time. So read this brief right about now on Del Bowman that's in this lesson. And you're going to really, that's a real eye-opener. That's all I'm going to tell you, and I'll let you draw your own conclusions. Now, the subject matter of a warrant, and in this state they never return these warrants, but they have to have a warrant for your arrest. When you have a warrant issued for your arrest, it's done by the judge, and by our rules you're entitled to a copy of the warrant, and it has to be returned to the judge and signed by the judge. Always motion up the warrant and the return on the warrant. It's a matter of due process, and you're entitled to see it, because you see, if you were arrested illegally and unlawfully, not only would that be important evidence for you in a Title 42 suit, but it can also be reversible error and a lack or a fault in due process. Now, that's called a technical move. There are a lot of technical moves, and as we go through this series, I'm going to tell you and reveal to you many of these technical moves, and this occurs also during motion hearing. This demand for the return on the warrant is one of those technical moves. It may only help you one time out of 10, but you know, when you're shooting for victory and you win because of that particular move as opposed to another technical move, all the better for you. Now, while I'm on the subject here of motions and due process, I'm going to show you a technical move here that I've used, and about 10% of the time it'll work, and you'll win for failure of the prosecutor to prosecute. Now, here's the way this one comes down. I want you to notice here again, I've got a big thick file folder, don't I? Well, you're not going to file all of these motions at the same time, or briefs or arguments, nor are you going to argue all of them at the same time. So what you do is you go in and you take about, let's just take a little sample here. Let's say that you get 5 or 4 or whatever you've got here, okay? Remember, you go up to the clerk. You've got to have these in triplicate, right? So you've got your original. You make your 2 copies. You go up and have the clerk stamp them in. You go over to the prosecutor and deliver his copies to him. And you take your copies and come back and write them into your list of motions and briefs and keep them in order. And let's say you do this, on the 1st of March. Then you come back and you call the court and you motion up a motion hearing pursuant to the rules. And we're going to have a motion hearing, let's say the 24th of March. So about 3 weeks from the time you file the first 4 or 5 motions, you're calling a motion hearing. All right, about the 10th you go in and you file another 3 or 4. And then about the 17th or the 16th, which is about 5 days before the motion hearing, you bring in another 4 or 5. Now remember, you have to have a notice of hearing filed. And so in the 3rd batch, that is about these 5 or 6 right here, this is your 3rd batch. You take your notice of hearing, which is 1 page, and you stick it right in here. Okay? You walk in. Oh, hi, sweetheart. Hey, I got some more motions for the prosecutor, and you drop them down. See you next time, and you turn around and walk out. Now, I'm going to send you a notice of hearing. Write that down. Make sure that's in this batch. Now, what have you done? These guys very seldom ever read your paper. They just take that paper and stick it in the file, and sometimes they'll have as many as 3 or 4. I've been into court and had 3 or 4 different prosecutors work on the same case. That's how disorganized they are. All right? So I'll take advantage of their disorganization and the fact that they don't have their paper together and the fact that they don't spend sufficient time, effort, and energy on my case. And now I've noticed them up, and I've got his secretary to stamp them all in, and then I always go in with 2 witnesses. So here I am in there dropping the notice of the hearing on the 24th on this fellow, the prosecutor, and I go into the motion hearing and I sit down and I take my 2 witnesses with me, and we sit down and this prosecutor doesn't appear. Excuse me, Your Honor, would you like me to check out in the hall and see if Mr. Johnson is out there? Oh, yes, I will. And I'll go out in the hall. Gee, Mr. Johnson isn't here. Did you notice up the prosecutor, Mr. Gordon? Oh, yes, sir, I did, Your Honor. And if you'll notice, on the 16th of March, I noticed up the prosecutor, and if you'll notice, the prosecutor's stamp is on your copy, sir, because I served him first, And, of course, I have a copy stamped by the prosecutor also. And, of course, it's been duly stamped by your clerk, sir. And it's for that reason that the prosecutor is absolutely notified, and I move for dismissal now, Your Honor, for failure to move forward and prosecute. Pursuant to the rules, he has to dismiss because the prosecutor has failed to move forward. I'm not saying you're going to win every time, but there's a good technical move for you. Don't ever forget it. Another technical move that you want to keep in mind all the time is a move that's called the Speedy Trial Clause. Now, I don't know where you are and what your rules are, but check the Speedy Trial Clause because that's a constitutional right that you have, a speedy trial. Well, in Idaho, it's 6 months. So if they don't get you to trial in 6 months, you don't tell them that they've scheduled the trial over the 6-month rule. You keep your mouth shut about that until the morning of the trial, and you walk in and move for dismissal for failure to provide you with a speedy trial. I've done that twice in 5 years. Like I say, you're not going to win every case that way, but that's 2 cases that I didn't have to take to trial because the prosecutor and the judge didn't keep track of the calendar correctly. And I've probably got 5 or 10 cases. I've never kept track of them exactly, but I know numerous times they failed to show up for a motion hearing. And every time they do, you move for dismissal, and there's another win and another win. All right? Now where are we? Now we come up to a thing called the summons. Now a summons is something that's normally used in a civil matter, but occasionally you'll see it in a criminal matter. Now let's take a look at the summons. Now when we're talking about summons, a summons is an invitation to a confessional. Now if you're a Catholic, that's probably all right. But if you're not, just bear in mind that a summons and a subpoena to an IRS hearing are probably invitations to confessions and admissions that are protected by the Fifth Amendment. Now what we're going to do in this lesson, from this point on, I want to show you this particular document. And it's stapled together, and it has a letter on the front of it. Take a look at that letter. Zero in on that so you can identify it. I want you to notice that that is an invitation to come to an arraignment. It suffices as a summons. It's not an actual summons, and we'll take a look at a summons from a court. And we're going to take a look at what our Supreme Court has said about it. But take a look at this document, and you'll see that it's stapled together. Follow through here for a moment, and let me show you the kind of paperwork you have. Let's read this letter of August 11, 1982, which is marked number 1. It says, "Please be advised that your presence is necessary for an arraignment on the charge of malicious injury to property in front of the Honorable Wayne Willis on the 16th day of August, 1982 at 2:30 p.m. I'm going to send with this lesson package this file folder, and this file folder is marked dismissed, and it's a felony. Originally, this case was brought as a felony, and the case number is CR 10960. And unlike any case files that you've probably received in the past from any other source, this is a charge of felony, destruction of jails, brought in the state of Idaho, successfully argued up to a motion hearing and dismissed by the state. So this is a case where we have a victory. We have a citizen charged with a felony who demanded all of his rights, who went into the courts and won the case. I don't know how many pages are in here, but it includes the transcript of the preliminary hearing. This then gives you an entire case to look at. The names of all of the motions and briefs, the affidavits, the arraignment and plea. I want you to look at that, and I want you to research it, I want you to read it, I want you to know it, and I want you to understand it. If you'll do that, when we, in later lessons, talk about summonses, motions, and proof, and affidavits, and testimony, and transcripts, in terms that are axiomatic in law, your computer then up here will have this information in it. In addition to that, when you're doing a case, you can always refer then to this file and say, well, what did Gordon do? Oh, he filed a notice and demand. Gee, that's different than a motion. Wonder why he did that. Oh, I see, here's an affidavit. Here's the form of an affidavit. How do you write an affidavit? It's in the file folder. And I've seen some cases that people are selling all over the country, and you get to the back page, and, well, what was the final adjudication in the case? Well, it doesn't say. Well, did he win or did he lose? How did he handle that? Well, when we're talking about Orson's Inn, we're talking about people who always win. And the reason that we always win is because we always file a ton of paper. Because it's that ton of paper that sets out your theory of the case and brings before the trial court your demands for your rights. You know, they're going to try to prosecute you in a felony, at least they do in this state, by information, because they do not want to convene a grand jury, because that interrupts the power base of the courts. They want to decide what is and what is not crimes. And so they use all these Mickey Mouse types of forms which are in violation of your constitutional rights. So let's start off here. I'm going to get into this summons. I'm going to read that to you in a second, but I want to give you this little background on this summons, because let me tell you, these guys bring summonses and complaints and informations against people, and they're illegal and unlawful half the time. You're entitled to a grand jury indictment, and in your Fifth Amendment to your federal Constitution, it reads like this. No person, this is on page 28 now of your little Constitution booklet from the American Legion. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now, I never saw a grand jury. In fact, in this state, I've heard it said we haven't had a grand jury for 18 years. And I would assume that's correct because I've demanded grand juries, and I know of others who have demanded grand juries, and they haven't gotten them. So then, going back to this little folder, did you notice in this case, the felony was reduced to a misdemeanor. So I won the felony by dismissal of the prosecution. And then the prosecutor comes back and wants to charge me with a misdemeanor. Did you notice on the cover letter, I'm not summoned into court, I'm invited into court. And if I appear voluntarily in that court, then I've made a voluntary appearance and granted that court jurisdiction, haven't I? And if I haven't covered that already, that's exactly correct. Take a look at Bouvier's Law Dictionary under jurisdiction and find out. When you pay bail, you grant the court jurisdiction. So, never pay bail. If you walk into the courtroom, I've had judges sit there and they'll look at a man and say, well, I challenge the jurisdiction and I deny the jurisdiction of the court. Are you sitting in the courtroom, dummy? Yes. I don't care if you're sitting on the book racks in the back of the room. If you're in here, I've got jurisdiction because you've made an appearance. Okay? That's true. Now what you do, one of two things. You walk up and challenge the jurisdiction of the court, or you make a special appearance in writing first. In other words, don't just walk into the court. Make a special appearance by letter, certified, denying the court's jurisdiction, and let them write back and demand that you physically walk into the court. Because in equity, jurisdiction over your person is obtained when you walk in, and no one ever objects, do they? And failure to object is fatal. Turn over here then to the next page, which is called a complaint. You'll notice there's somebody named Tim Gass who alleges and says that George Gordon, on or about the 9th day of April, 82, in the county of Ada, state of Idaho, did maliciously injure certain personal property, to wit, a pair of coveralls. Now you'll notice that this one in the top says complaint criminal. When you see one of those, now you've got a lawful complaint signed by a judge. Down here at the bottom, it's not signed, but it's a copy. The judge signed the original. Well, at least I hope he signed the original. I know I made my appearance. Okay, then going on through here, you'll notice a motion and order for dismissal. They dismissed criminal number 10960, and then they brought it again then as a misdemeanor, and when they brought it again as a misdemeanor, the case number changed. It went on to the magistrate's division. Okay, there's your typical motion in order for dismissal. Now as you turn back here, you'll find a paper that's marked 6472, and it says 1C up in the upper right-hand corner. And it says CR, that's criminal, 25C, 2578, and it says summons on it. All right? Let's read through this summons. You are hereby notified. Excuse me, let me give you a little background. First of all, they sent me a letter of invitation, and I don't remember if I called them on the phone or I just didn't appear. It doesn't make any difference. An invitation to court is not proper service of process. And I always demand all of my rights, remember? So you walk in, you always demand all of your rights at all times and waive none of your rights at any time, including your right to time, for any cause or reason. And so now, after I failed or refused the invitation, now I get a summons. Now notice that you can be brought to court either under arrest, by warrant, or by summons, one or the other. Well, it would sure look stupid, wouldn't it, after they've dismissed the felony, then to arrest me and haul me into court on a warrant? Well, certainly, because now you've got malicious abuse of power, false arrest, false imprisonment. There's no cause or reason. I've already been released OR on the felony. See how that goes? So now we come to the summons, and it says, you're hereby notified that a complaint has been filed against you in the District Court of the 4th Judicial District of the State of Idaho, in and for the County of Ada, State of Idaho, by the above-named plaintiff, and you are hereby commanded to appear on the 7th day of September 1982. Now, here's a command from the court. At the Ada County Courthouse, 5th and Jefferson Streets, Boise, Idaho, at 2:30 p.m., to plead to and answer to a charge made against you upon the complaint of the Ada County prosecuting attorney for violating Idaho Code blah, blah, blah. And it's witnessed and it's dated and it's stamped by the clerk of the court. That's a lawful summons. I appeared. And then when I appeared, we had a second case. Now watch what happens. First of all, I'm charged with destruction of jail. Well, that charge wouldn't hold up because it was phony as a $3 Federal Reserve note. Then they bring back the same event in the form of a misdemeanor. Now, I won this one on a technical move because in the state of Idaho, under Idaho Code 19-3506, you cannot bring a misdemeanor twice. Now, I argued by motion, well, you can't charge a man with a felony and then reduce it to a misdemeanor if you can't bring a misdemeanor and then reduce it to a lesser misdemeanor. Judge saw it my way and dismissed. Don't confuse that, though, with the terms bringing a felony twice, because you see, you could bring a felony, murder one, and then reduce it to manslaughter and bring it twice. You could bring it a third time if it was a felony, murder one, murder two, and then manslaughter. So you could always reduce it, but you can't jeopardize the man's rights. And you jeopardize the man's rights when you charge him with a misdemeanor and then move it up and charge him with a felony for the same event. That would be a jeopardy. That would be a significant change in your status of rights. Now, I've never known of any court to do that or to allow that to be done. Now, there you have a typical, everyday, garden variety, run-of-the-mill summons. When you see one of those, obey it. Always make your appearances. Never fail to make your appearances. In fact, I'm so faithful in making my appearances, I had a judge tell me not long ago that probably in Idaho there isn't a judge who could charge bail and justify it. And I want to keep that kind of a record because there's no reason for us, the citizen, to miss our court appearance. That's my courtroom up there, and those judges are my public servants, and I want redress of grievance. I want my story on the record, and I want my story in the courtroom, and I'm trying to expose those legal criminals, or the lawful criminals called lawyers and other public agents who are violating our rights and taking and usurping powers that have never been granted to them and oppressing us. In ancient times, you know, we used to have lawyers in Jesus' time. They used to oppress orphans and steal widows' houses. Today we have lawyers, and they still oppress orphans, but now when they steal widows' houses, we call that probate and escrows, don't we? See, we just change the names, but we don't change the character of the animals who are doing the theft. Now, I'm not suggesting that all lawyers are bad, wicked, terrible, and awful any more than I'm suggesting that all truck drivers are alcoholics. But we seem to have a tremendous proportion of people who have positions of trust, who utilize the law and bend it, warp it, and twist it, quote it out of context, and then use that under color of law to oppress people. Now, I want you to pick up your book here on legal quotations and follow along with me, would you? Remember the green book on legal quotations? Here's a little gold mine of all kinds of nifty Supreme Court statements and rulings and law. And by the way, this is the law of the land. I didn't write this, so don't call this 1 Gordon 14:4. I don't take any credit for it. But there's a case called United States versus Minker. That's U.S. versus M-I-N-K-E-R. It's located on page 25 and 26. I want you to turn to page 25. The citation is 350 U.S. 179 at page 187. Now follow along, and I want to show you here's a summons from the IRS. And let's take a look and see what the Supreme Court of the United States has to say about our government agents who wrest and twist the law. Number 63 is the quotation, and it says, the subpoena power is a power capable of oppressive use, especially when it may be indiscriminately delegated, and the subpoena is not returnable before a judicial officer. True, there can be no penalty incurred for contempt before there is a judicial order of enforcement. So when we flip back over here to this prosecuting attorney's lesson, and I'm following along here in this little packet, you'll notice, please be advised that your presence is necessary. So here they are advising me that they want my voluntary presence in the courtroom. Well, that's a bunch of poppycock. You can't hold me in contempt of court if I don't show up with an invitation sent by the prosecuting attorney. There's no judicial order, so therefore there's no way to enforce it. And so I don't remember whether I appeared or not. Sometimes I'll make an appearance just to have a little fun. But typically on one like that, you don't make an appearance. You wait until you get a summons. But the subpoena is in form an official command. And even though improvidently issued, it has some coercive tendency, either because of ignorance of their rights on the part of those to whom it purports to command, or their natural respect for what appears to be an official command, or because of their reluctance to test the subpoena's validity by litigation. So here's your Supreme Court telling you in plain language that a lot of people just obey things like this, a letter, a subpoena, a summons, and it can be an executive summons. It can be a summons from the IRS or OSHA or EPA or some other Mickey Mouse outfit that wants you to come in, bring records and books, etc., incriminate yourself and give them information. So your court, your high court, that is our federal Supreme Court, recognizes these phony baloney summonses and subpoenas. The points that should be remembered, the high court goes on, that one, the subpoena power in the hands of an administrative officer can be very oppressive. Well, I'll second that one. Number two, neither the IRS nor any other administrative officer can compel obedience to an administrative summons. Only courts can enforce it. See why you don't have to enforce something like that? Or you don't have to obey something like that? It's unenforceable. Because of what appears to be a lawful command on the surface, this is number 3 here on page 26, many citizens, because of their respect for what only appears to be a law, are cunningly coerced into waiving their rights due to ignorance. And you just take a look at this first page here. Doesn't that look pretty official? It's got the prosecuting attorney of Ada County on there. It's got his letterhead. And number 4, the use of an administrative summons is very effective in obtaining information which could not otherwise be obtained, because it appears to be official and legal in form, and as a consequence, citizens are reluctant to test its demand for information. And so there you have it in a nutshell. Bottom line of it is, you must look at the paperwork and determine whether or not it's a lawful summons or whether it's a lawful warrant even, or a lawful Fourth Amendment warrant. Always check the paperwork and make sure that there's a seal or that there's a judge's signature on there. If necessary, call the judge. Do you issue this warrant, Judge? And after you get started in your community, it won't take you very long until you know who your judges are. For instance, when I see one that's signed by a judge here, I recognize it, and I recognize the stamps of the court clerk. When you first start off, you won't be so knowledgeable. And there'll be some mistakes made, but don't let that bother you at all, because remember that these rights that you're talking about, flip over here to page 32 and follow along with me. Number 87? This is number 87 in the same book here, Legal Quotations. You have to always bear in mind that the privilege against self-incrimination is neither accorded to the passive resistant nor the persons who is ignorant of his rights, and not to the one who is indifferent thereto. That's exactly what your court just told you. You know, a lot of people obey this kind of Mickey Mouse phony baloney summons because it looks official and because of their reluctance to test the issue by litigation. I always test the issue by litigation. It is a fighting clause, your rights are, and the Fifth Amendment is. Its benefits can be retained only by sustained combat. You've got to challenge these things by litigation. You've got to go into the courts yourself and say, wait a minute, Judge, I'd like a judicial determination as to whether or not this is a lawful summons. Is it the position of the court that this letter issued by the prosecuting attorney is lawful due process and service of process? Check your own rules in whatever state you're in. In our state, I forget the name of the rule, check the rules in whatever state you're in and find out service of process. Now, this comes early on, so it'll be somewhere before Rule 12 here in the state of Idaho, probably Rule 5 or 6. In fact, I think it's 5.2. It can't be claimed by an attorney or solicitor. You can forget about your attorneys claiming or demanding your rights. Now, an attorney could tell you right away whether you ought to obey this summons or this complaint or not, or this letter. I'm not saying that an attorney is incompetent and can't give you legal advice. I'm just saying that you yourself must be knowledgeable enough to look at this kind of Mickey Mouse paper and take a look at what your Supreme Court has said about this kind of thing. They just told you that it's phony baloney, and people waive their rights, don't they? So when you get to Washington and after you've waived your rights, the court's going to say, well, you waived your rights. Sorry about that. But if you're that belligerent claimant in person, this one where it says it is valid only when insisted upon by a belligerent claimant in person. So you better be that belligerent claimant in person, because if you're not, then you're going to fall prey to these Mickey Mouse summons. All right, now let's go on here another step and see where we go. I want to show you now this thing called an information. Would you zero in on this one? And there you have an information. Right up there in the corner it says information. All right, now what is an information? An information is permission by you, the defendant, to prosecute you for a felony without benefit of a grand jury. Well, in the state of Idaho, we don't have grand juries here anymore. We have under Rule 6 of the Idaho Rules of Criminal Procedure the methodology for calling a grand jury. It requires a district court judge to do it. So when you get into the district court, and I'm going to an arraignment for a felony on Monday, what I'm going to do is walk in, and they're going to hand me an information or a complaint, one or the other, and here I am charged with a felony. So I'm going to go in and demand my Fifth Amendment right to a grand jury, and the judge is going to really come down on me. I mean, he's going to tell me the law and why the law is this way and how I have to plead. When he does that, which right is it, Your Honor, I have to give up in order to have my right to a grand jury? Those one-liners, you know, are really nifty. And you know where all those one-liners come from? Did you think that I was born with all of these nifty quotations, you know, like the slippery slope and some of these quotations? No, I get it right here from the federal Supreme Court, especially these on counsel. I really enjoy these, and I'll bring it to the attention of the court. Your Honor, let the record show that I'm appearing here without counsel, but my counsel is Mr. Neelis Cook, and he's sitting right back here, and at this time I'd like him to come up here and begin to assist me in this hearing, because this arraignment is one of the meaningful hearings guaranteed me by due process of law, and I have substantial rights at stake here. And he's going to say no. Well, he's going to ask him, is he a licensed lawyer? No, Mr. Cook isn't licensed at all. He's my next friend. Lack of counsel of choice can be conceivably even worse than no counsel at all, or of having to accept counsel beholding to one's adversary. Well, that comes from a case called Burgett versus Texas, 389 U.S. 109. I'll quote that case and 5 or 6 more, and I'll do it right out of legal quotations.